cases that are quite this discovery, have this much discovery over this many years, over this many detectives, et cetera.
The original discovery, what we had at the time of indictment, has been supplied to the SPD, and I believe it was complete. Since that time, we've actually gotten quite a bit. In fact, the number of the exhibits attached to our opposition came in shortly after our receipt. So there is additional discovery to provide them, and I also anticipate that there will be even more discovery required between now and June.
Okay, so I think it's safe to say we're working on it.
Correct.
All right, we'll do another status check, maybe 45 days. Does that work for the parties regarding trial readiness? Okay, that date will be?
That's February 20th at 9 a.m.
All right, now that that's been dealt with, let's move on to the defendant's motion for release of zone recognizance on an alternative to set a reasonable bail. Mr. Arroyo, it is your motion. I did read your written motion as well as your reply. Anything you wanted to add or anything you want to highlight at this time?
Yes, Your Honor, I'm not going to rehash everything in it, but there's some things I did want to highlight for the court.
Of course.
I know this court's got two separate decisions to make, whether or not Dwayne should be denied bail outright. If he is granted bail, is that a monetary bail or is there something least restrictive, such as electronic monitoring, house arrest? Today we are asking Your Honor to release Dwayne on house arrest on electronic monitoring. As we said in our motion, he's not a danger to the community, he's not a flight risk. And I think the overwhelming thing, the question that's looming out there is, if Dwayne is so dangerous, if this case is so overwhelming, his guilt is so overwhelming, what's been happening for 15 years? Why did we wait 15 years to make the arrest? The state has attached his 2009 statement to Metro. They attached the proffer to this court. They've been taking the position that he has no immunity, that they can use the statements against him. If that is their position, then why wasn't he arrested in 2009? At the earliest, I mean, we know that he spoke to Metro. And
I don't think the state has said that the proffer is admissible yet. I don't think that we've crossed that bridge.
Yeah.
But any additional statements, I believe, have been tendered to this court and I believe could be properly considered.
Yeah,
Is that
I
the
think
accurate?
Mr. Wall is going to address the proof of presumption is great, and we'll address both the 2008 and the 2009 statements, as well as the reasons for why he wasn't arrested after making that statement in 2009.
Okay, sounds good. I'll let you guys do that at some point. I'll go back to you, Mr. Arroyo. I apologize for interrupting.
But, I mean, they did tell the grand jury that he did give a proffer in 2008. They told the grand jury about that. They did say that 2009, that Nevada hasn't promised anything. So that position, at least since 2009, this information has been known to Nevada. I think what the problem is, there's really no corroboration. There's no gun. The white Cadillac was never found. There's nothing to corroborate anything that was said in Dwayne's statements. I also believe, you know, like I said in the motion, there's problems. They rely heavily on what was said in the book. The author was never called to the grand jury, so we don't really know what parts are Dwayne's statements, what parts are the author's statements, what's been dramatized for purposes of the book. So really, we're missing this lack of corroboration of the statements. The state does try to address this corroboration issue with Devonta Lee at the grand jury, as we said in our motion. He is not a credible witness. He was interviewed several times by the authorities. The grand jury wasn't told this, but he did previously say that Big Dre is not the shooter previously. He was specifically said, I asked Dre, and Dre said he's not the shooter. That's what his statement to police were before the grand jury. He told the grand jury he was in jail, or back up, he told the police back in 97 or 2007, 2008, that he's never seen a white Cadillac. Then he tells the grand jury, oh, I did see a white Cadillac. But then he also tells the grand jury, well, I was actually in jail at the time all this was happening. So he lacks all credibility. And he's inconsistent in his own testimony. They also try to connect this with Malcolm Greenidge, who was in the car behind Mr. Shakur at the time of the shooting. And they say, well, Devonta Lee's allegation that Big Dre is the shooter is corroborated by Malcolm Greenidge's testimony at the grand jury. But if you look back at what Greenidge said at the time of the shooting, just hours after the shooting, and I did not attach this to the motion, but at the time of the shooting, Greenidge said he couldn't see what type of arm was out of the car. The grand jury, he says it's muscular, but previously he said he couldn't see it. It happened so fast, all he saw was a black arm with 2 people in the car. It's different from the 4 people that is alleged to be said by Dwayne. So I think you just have all these inconsistencies. You have these statements that have changed over time. And, part of the problem is this case has been tried on YouTube already. There's been so many interviews given, so many different stories thrown out in the public, that things change over time as people are picking up bits and pieces from these YouTube interviews that are out there. I think this whole YouTube narrative plays a part in this. I think there's concerns that Devonta leaves after his 15 minutes of fame. I did attach a link to a Vlad TV interview where the interviewer, Vlad, says, hey, Devonta Lee, I've been in talks with him. He's going to come on. He says, I actually talked to him way before I talked to Dwayne. But who's going to pay Devonta Lee for an interview that he's just saying the same thing that everybody else is saying? So now he's coming up with this counter-narrative years after the fact, but when this actually happened, he's saying he doesn't know anything. One of the biggest issues also is, Suge Knight. The grand jury never hears from Suge Knight. I know the state says, hey, it's no secret, Suge won't cooperate, but there's been no attempts to get him here. He's incarcerated in jail. He has no choice. They could have forced it or compelled his appearance here at the grand jury. And I think that the statement by that he's never cooperated, I don't think that's accurate. He does give a statement after the fact. In 1996, he gives a 30-page statement to Metro. He just says he didn't see what happened. So, this doesn't corroborate, it doesn't match up with what Dwayne's saying, or alleged to have said in the book. The book says, hey, we pulled up and me and Suge, we locked eyes in this really dramatic, intense moment. And Suge's saying, no, I didn't see what happened. All right, if this was true, if this corroborated, Suge and Dwayne know each other since Pop Warner days. He's going to know if Dwayne's in that car. They should have heard from him. And he did give a statement. He has cooperated with Metro before. If this court is going to, find some of these statements that are credible and you are going to consider them, the statements don't support that Dwayne actually ordered the shooting. The shooting, the book and some of the interviews talk about they were going to meet up with Shakur to get the rematch, the one-on-one. And Anderson was jumped at the MGM. It was multiple members of Shakur's entourage, and it was just Anderson alone. Right? So the book and some of these interviews talk about we were looking to go get the rematch, the one-on-one fight. They said when they pulled up along the car, it appeared that Shakur was reaching for a weapon. And the state says that no weapon was actually found, but in Nevada, you don't need to actually, find a weapon. There doesn't actually need to pull a weapon. Appearance is enough for self-defense. If they appeared that he was in danger. But I think here it's not far-fetched to think that Shakur had a gun. I mean, he was on parole, or he was on bail pending appeal. He's a convicted felon, sexual assault. He shot 2 off-duty cops. This was well publicized. He was just involved in jumping Mr. Anderson in the MGM while out on bail on one of the most crowded nights at the MGM. It's not far-fetched to think that he was going to commit an act of violence. In regards to dangerousness. I addressed this in the reply in depth because I was really worried when I saw this allegation that there was a green light. And that word itself is inflammatory, it scares people, and I think there was an issue that I was worried about was the media was going to pick up the word green light, and they did. And I put some of the headlines that have been run now saying, Dwayne orders a green light against witnesses. If you read what the state's actually alleging, they never say that Dwayne ordered the green light, because there is no evidence of that. If you listen to the phone call, there's actually no threats being made, right? He doesn't even mention witnesses. There is a discussion about something that was heard on the streets, that there's a green light on our side. And Dwayne's asking what? He doesn't know what it's even being talked about. And I believe the correct interpretation of that is there's a green light on our family. There's word out there that our family is in danger. Not that, hey, Dwayne ordered a green light, because that's not supported by the phone call. I know the state has listened to every single call he's made since he's been in custody. If there was a green light order, it would have been submitted. He doesn't mention witnesses, let alone threaten any witnesses during the phone call in question. There was also allegations that Devonta Lee was moved because of this green light. I don't see any support for that, that he was moved because of this. As we say, it's pretty clear he's working with the FBI, that he's a federal informant that testified in one of the biggest cases, the most highly publicized cases. So it's not a surprise that the feds will step in and move him on that. But there's absolutely no threats from Mr. Davis towards Devonta Lee. As we said, Lee is younger, he's a violent gang member. If anything, it's Davis and his family that should be worried about Mr. Lee. There was also an email addressing another witness where they said that I was going to give a statement to Mr. Davis's son, and that once the public knew about that statement, the witness was done. As I said in my reply, we're talking about YouTube. And I asked the court to Google the name and see how many interviews this witness has done. This isn't a surprise. It wasn't like we got this discovery, we're learning about stuff that wasn't out there in the public. This witness has been given YouTube interviews for years, and he didn't even testify at the grand jury. But this is all about this YouTube world where all these people are coming in and they're giving these stories. And as I said, this isn't, I don't know if Your Honor is familiar with wrestling. This is WWE, this YouTube life. This isn't real life. These people, Dwayne knows these people in real life. They have each other's numbers. If you look at the statement from Reggie Wright Jr., he says, hey, yeah, on these YouTube interviews, I talk bad about Dwayne, but hey, I have his number. I try to hook him up and try and get him paid on some of these interviews. I mean, these guys, Dwayne's 60 years old. These guys are old now. They're grandfathers. They're trying to do these interviews, trying to make money. Nobody's going to click. Nobody's going to watch if they're on there reminiscing while at the park with their grandkids. Conflict sells, and that's what they're trying to do. They get on these interviews. They puff their chest. They're trying to get clicks. There was also the witness list, and there was an issue with the witness list. I don't know if that should be characterized as a witness list. If you see how old that document is, it's from like 1996. It's a list of people that were raided back in Compton when this incident first happened. This wasn't any surprise to Dwayne. Dwayne knew everybody on there. Half of the people on that list aren't involved in the case. Half the lists are dead, or half Dwayne knows already. So this wasn't, the list makes it to his son, right? We don't know how it got there. There's an allegation that maybe his prior attorney gave it to him, which seems likely since it has the attorney's phone number on it. And
Not his attorney.
well, the person that was going to be his attorney before conflict was found. All right? But this isn't rare. I mean, all of our defendants want their families to have their discovery. There was no threats actually made. There's nothing on here where they just said, hey, go find these witnesses. Like I said, none of them are even, none of them were called to the grand jury. The majority of them aren't even involved in the case. This is a list from 1996, people that were raided in connection with the investigation back then. I listed out his medical conditions. He is, his cancer is in remission, but he does have heart issues. He's not getting proper treatment, proper diet, proper exercise, Your Honor. He is a father, a grandfather. He has support of his family here today. He had more people here last week, but this was continued on my request. But he had a lot of family in from California last week. He does have support. He made an oath. He did give that interview with federal authorities in 2008. He made an oath to walk away from the life. If you listen to that tape that was provided, he says, "I'm retiring. I never thought I'd say this. I'm retiring. I'm giving up this lifestyle."
Doesn't he sustain a parole violation in like 2016, 2015?
The state puts that in their opposition. I don't have any indication that he went to prison in 2015, 2016. I know that was around the time he was having surgery for his cancer.
We provided the judgment of conviction in discovery for his conviction for a felon in possession of a firearm. He was arrested with both drugs and firearms, was convicted from a 2013 arrest and 2015 conviction in California.
And was he incarcerated as a result?
I believe he did about 6 months on a 2-year sentence.
Understood. Okay.
All right, but there's no connection to this gang life or anything that they're alleging. Your Honor, he has been, employed before he got sick, before he got the cancer. He was making an honest living. As I said, now he is at home with his family. Before he was arrested, he did not flee. He knew this was coming down. He got the Markham notice. He could have ran if he wanted to. He's been under investigation throughout his life, talking to the federal authorities, the Nevada authorities, California authorities. He's never ran. There's no evidence that if he is released with bail or monitoring, that he is going to flee. He will return. If he was going to run, he would have did it back in the summer when he was served with the Markham notice. So.
Thank you, Mr. Arroyo. I understand your request. State, I'm going to turn to you to address the issues that were brought up, including the lack of corroboration and the fact that, if we're taking his statements at face value, they include some sort of baked-in lesser charge.
Yes, Your Honor, just so the court's aware, I was planning on handling the primary argument, and then Mr. Giacomo was going to deal with the supplement that we thought regarding the dangerousness and the clean right. That's okay with the court.
So you're going to address if there's proof evident, presumption positive, as well as with the majority of the factors. Mr. Giacomo is going to address bail factor 6 or 7.
Right, yes.
Okay,
That's
understood.
okay. Your Honor, in listening to defense counsel's argument, one of the things he said is there are all these inconsistencies, but there is one constant, that Mr. Davis has consistently admitted to being the architect of the murder of Tupac Shakur. The state's position is that the proof is evident and the presumption is great. Now, there's reference to this case being 15 years old in terms of the statements, but the 2008, if you listen to it, is clearly a proffer, right? It's not immunity, it's a proffer, meaning that we can't use his statements outside of that room unless he disavows or says that he was lying in making those statements, which is precisely what happened here in the defense's moving paper. But in 2008, we certainly couldn't have filed charges based on the 2008 statement. In the 2009 statement, we were unclear, in perfect candor of the court, of the circumstances surrounding that statement. Frankly, until Mr. Giacomo alluded to the fact that we're getting more information now, even post-indictment, we got more information regarding the circumstances surrounding that statement only in the last few months. Clearly in the statement it says that you're not being promised anything. However, there are an abundance of caution we could not proceed just based on that. And as the court should know, we didn't even submit that to the grand jury. We didn't submit that statement to the grand jury because we were just had some concerns that I think have been alleviated since then, but there were some concerns. So there's no immunity. There's this notion in defense counsel's moving papers that this is all for entertainment, and I think if you listen to the 2008, 2009 statement, you clearly hear that this is not for entertainment. I don't think that's true. So this court asked me about corroboration. Well, the first thing is that in any instance where we've had somebody confess to a murder, you usually don't have to corroborate with great detail their confession. But there is corroboration here. First, the whole setting. Mr. Davis was the leader of the Southside Compton Crips. Well, that's corroborated by Mr. Davis makes that statement. Detective Ladd, who was a patrol officer, then a gang detective in Compton from 1983 to 2000, corroborates that as well. Mr. Lee, who was a member of Mr. Davis's gang, corroborates that as well. Even Mr. Wright Jr. talks about Mr. Davis being a shot caller in that gang, or high-ranking member in that gang. Well, and trying to connect to the event. Well, Orlando Anderson was also a member of that gang. That's been corroborated multiple times. Orlando Anderson is the nephew of Mr. Davis. Corroborated, undisputed. Okay, so you have the fight that occurs at MGM. Corroborated, undisputed, right? And it's actually on video. So then you have Mr. Davis saying, leading this group of people in a white Cadillac. Mr. Lee says he does see them in a white Cadillac shortly after the murder occurs, right? They see Terrence Brown in a white Cadillac shortly after. You have DeAndre Smith's statement about being in the Cadillac for the murder of Mr. Shakur. And you have Malcolm Greenridge's statement saying, I saw the white Cadillac go up to the vehicle. I saw a large arm come out of the vehicle and shoot at and into Mr. Knight's and Mr. Shakur's vehicle. And, Your Honor, like, if taken at Mr. Davis's statement at face value, that would be enough. I think the statement submit for proof of innocence of the crime. But taking the connective tissue you have from Detective Ladd, from Malcolm Greenridge, from Mr. Lee, from we had one of the females who were out there in the street when this occurred. And part of Mr. Davis's statement is, yeah, there was these females, that's how we knew where Mr. Shakur was. There was these females yelling at the car, Tupac, Tupac. Well, what do we have? We actually brought one of those females saying, yeah, we were talking at that car during this time. So, and, I think part of the struggle with this case, I think to wrap your head around it is, the question is, why would Mr. Davis admit to this in public, right? Multiple reasons it could be. He could have been under the false understanding that he was given immunity. But that doesn't immunize himself in and of itself. But he also gives an explanation in one of the trailers, I guess, for the Death Row Chronicles, one of the interviews he did. And it's addressed a little bit by defense counsel, which is, I have cancer. I have nothing left to lose. Because he was given a serious diagnosis of cancer back in 2017, and he says, I want to set the record straight. When they talk about the book, about we can't prove what he wrote versus what the authors wrote, but again, we just refer back to Mr. Davis's own statement on video, where he says, while holding the book, this is the truth. I was the only person that was there. This is the truth. It is stamped, homeboy. Those are his words, not mine. And so he's saying, I am endorsing, and I am saying, and I am validating everything that's in here. The problem for defense is that their defense is, our client's a liar. That's the defense. Our client is a liar. He lied to police in 2008. He lied to the police in 2009. He lied to the Death Row Chronicles in 2007. He lied to his book in 2018. He lied in his YouTube interviews from 2019 to 2022. And Mr. Arroyo said, this is not real life, and I take issue with that. To the family of Mr. Shakur, this is very much real life. This is very much real life. So I do take issue with that. And Your Honor, there's something that's very disturbing. Is like this kind of character assassination of the victim in this case. In the reply brief, it says Mr. Shakur was a violent person. Certainly, he got into a fist fight. He and some other guys jumped on a guy for 20 seconds. That doesn't come with a death penalty. They also reference his sexual assault, failing to acknowledge that he was acquitted of the sexual assault counts. And I think we have to be a little more precise when we're talking about the convictions, just as we would be with Mr. Davis. Certainly more precise when we're talking about the convictions of Mr. Shakur. And the other thing I'd ask is, what relevance does that have? It certainly doesn't factor into a Daniels analysis in terms of self-defense. It's just there to impugn the character of somebody who is no longer here. Lastly, Your Honor, I want to talk about Mr. Lee, because Mr. Lee does corroborate some of the stuff that's done in this case. And they say Mr. Lee is looking for his 15 minutes of fame. Well, I think it's a mischaracterization of what that YouTube video says. I think the YouTube video, the person who does that, runs that channel, says that, hey, I'm trying to reach out to him, I'm trying to get him to come on. He hasn't gone on. He hasn't gone on. But more importantly, the person who tells the police that Mr. Lee has information about this murder, in 1996, Mr. Lee says, no, I don't know anything about it. Who redirects the police to Mr. Lee after the decade has gone by? It is Mr. Davis in his interview when he's giving his proffer. He says, you know who knows about this? When he's talking about some of the elements of the murder? Dirt Rock. That's Mr. Davis who says that to the police. So Mr. Davis is the one turning the attention to Mr. Lee. It's not Mr. Lee that had come forward. It was Mr. Davis that said, hey, he has information. He can corroborate my story. And he did. And lastly, Your Honor, and then I'll for Mr. Giacomo, is this notion that somehow this could be self-defense. Mr. Davis says, I got a firearm from Eric Martin for the express purpose of shooting Mr. Shakur. We drove to Club 662 for the express purpose of a violent confrontation. And what Mr. Davis says is, look, if it didn't go the right way, it would have been St. Valentine's Day Massacre there. And what is that referring to? Obviously, a gang murder in Chicago where 7 gang members were killed by a rival gang. So that was the mentality. And then, when he is driving one way on Flamingo and Mr. Shakur's party is driving the other way, it is he, in every iteration of his story, says, we made a U-turn to go after them. And what are we to believe the purpose of that U-turn was? Was it a Yalta-like peace conference? Absolutely not. They have the firearm provided by Mr. Davis to the shooter, and what happens? The logical thing happens. What's Mr. Shakur doing during this time? What's Mr. Knight doing during this time? Indisputably, and according to Mr. Greenidge and to the females that they were talking to, they were going to the club to perform and to party. They were not the ones seeking the violent confrontation at this point. There was one person who forced a lethal confrontation, and that is Mr. Davis. Self-defense is not available to him under these facts. I think I addressed most of your concerns. If there's anything else in particular, I'm happy to do it. And then Mr. Giacomo is going to talk about the business.
Go ahead.
And Judge, when I listen to Mr. Arroyo here, it's a discussion about there's no threat to these individuals because they've all been on YouTube telling this story. If he wanted to harm these people, he could have done it because they're all on YouTube. But he's missing the central fact here because apparently every gangbanger on earth can get on YouTube and talk about crimes. But when it comes to talking to a police officer, that is a unique thing. It's a thing that'll get you killed. And so why did I give you the exhibits, and one of which I provided a disc to your clerk today of Exhibit 8. I asked to have that filed under seal. And I'm somewhat disappointed with Mr. Arroyo for publicly naming this particular witness. I'm going to talk about him as a high-level Mob Pi group member. And here's why. When you look at the 3 facts we put in front of the court, which is that Mr. Westbrook, I will say it was probably both unethical and ridiculously dangerous to provide a list of 39 people and tell Mr. Davis that these are people that have provided information to the police about this situation. Mr. Davis then has a conversation with his son, and his son requests that list from Mr. Davis, and he says, well, I can get it to you, or maybe Mr. Westbrook can get it to you. I don't believe from the nature of that picture that Mr. Westbrook provided it to Dwayne Davis Jr. I believe because of the way you see the folds in the paper that Mr. Davis mailed that list to his son. What was the purpose of mailing that list of 39 gang members who allegedly provided information to the police about this homicide? Then you have the phone call. And I agree with Mr. Arroyo. Mr. Davis, I'm not the newspaper, I'm not the media, and God knows if I were writing the stories, I'd get it correct. I never alleged that Mr. Davis issued a green light. What happens is, there's a discussion, and Detective Mogg's here. You can have Mr. Mogg put under oath and talk about the number of times they discussed this list and that these people are people that have provided information to the police. And then there's a phone call in which Mr. Jr., Dwayne Davis Jr., tells his father, hey, I got some news for you, that there is a guy, and there's some confusion on Mr. Davis's part about, he's put up a green light, which in Mr. Davis's own words means an order to kill on our side. I took that statement to mean that anybody on that list who was a Southside Crip was at risk of being killed. They take it as, oh no, they're going to kill a bunch of Southside Crip people. They put a green light, the mob put a green light on us. Well, if that's true, then why is Mr. Davis's reaction during that phone call so excited and happy about the fact that there's been a green light issued and that we were born in war and this is war and all those other things? Why is he so excited about that if him and his family members are about to be killed? I then gave the court the high-ranking mob Pyru members' statement to police. Yes, all these people have been on YouTube and none of them are at risk of any danger because everybody apparently can be on YouTube. But nobody knew that this member had spoken to Detective Mogg. More importantly, he brings a crucial piece of corroboration that nobody knew, which is that he is at 662, he sees the white Cadillac, and that he knew that Southside was present at 662 prior to the homicide of Tupac Shakur. Meaning he's a critical piece of corroboration. And why is that important? Yes, everybody has said this in social media from 2017 on. But you now know that every single fact that every witness has reported since 2017 on YouTube was reported by Dwayne Davis in 2008 and 2009. Which means every witness on YouTube has corroborated what he said in an admissible statement that we now know is admissible to Detective Dan Long in 2009. And why those witnesses are so important is because there is no defense at this point to this particular crime based upon the statements he's made in 2017 and in 2009, because it's not until 2011 that Kading publishes his book and puts all this information out there. And thus, Judge, why is this important? Well, when you hear what this high-ranking member, they find out there's a statement to Mogg, and they're going to put it on the street. What does Mr. Davis say? He basically implies that Mogg will kill this guy on their own because he talked to Cliff Mogg. And that gives you knowledge of what it is they were doing when they disseminated that list of 39 gang members who allegedly provided information to the police. Why were they sending that out as a picture and disseminating it publicly? It's because he knew he doesn't have to issue the green light. He knows what the culture is because he was born in it, he grew up in it, and I dispute he ever left it. You listen to those calls and you know that he is a gang member to the core, that he has their mores, their values, and he presents a clear and dangerous threat to our community. And that he made an effort to cause harm to those 39 people on that list. He is making efforts to cause harm to the high-ranking mob Pyru gang member. He doesn't need to issue an order. He just needs to prove to the world that they talked to the police, and every one of them is at risk of death, which is why the federal government came in and provided money to Mr. Lee so that he could move his location. I would suggest to the court that not only is the proof is evident, the presumptions are great, but that he presents a very, very high danger to the community, and thus he must stay in custody.
Thank you, Mr. DiGiacomo. Mr. Arroyo, I'll give you a final word as it was your motion.
Mr. DiGiacomo was taking a huge leap here about these phone calls. All right. First of all, the high-level ranking Pyru has given multiple YouTube interviews from 4 years ago up to a couple of days ago. That's why I asked your court to review it. Nothing he says in that statement hasn't been said on YouTube for the whole world to see. All right, this is a person that says he's a former gang member. There's nothing in that statement that's not been said out in the public forum. That the statement about seeing that they say now corroborates a huge fact in this case about seeing Dwayne at the 662 Club. In one interview on YouTube, he says, "Oh, I saw him," and in the next interview, he says, "I never said I saw him." So he's even inconsistent on his own YouTube statements. And this is not a hidden witness that we had no idea who this guy was. Just Google him. See how many times he comes up on this. All right? We're not exposing some high-level secret government witness. He's out there giving a press tour every day, trying to make a couple of bucks on this case. Just like everybody else in this case, trying to make a couple of bucks on this case. If we're going to talk about putting people in danger, let's talk about this green light call. All right? The allegation is that Mr. Davis's son says, "Hey, I heard something on the street from a guy named B. Brew." Right? That B. Brew is saying it's on. It's a green light on our side. I don't need to pull in a gang expert in to know that B. Brew is a Mob Pyro Blood nickname. It's not a Crip nickname. So now by putting that in the pleadings, now every Blood gang member in California knows that it's Mr. Davis's son that's putting out this information. They've made their family more in danger now of retaliation. The threat is against Mr. Davis, right? There's a green light on our side, on our family. He doesn't even know what his son is talking about in that phone call. He's not making any threats. He's not saying, "Oh yeah, good, make sure that gets carried out." He's saying, "What? What are you talking about? Huh?" He can't even really hear what's being said. And I hope the court has listened to that phone call, because I think the way that Mr.
I've listened
Jamalco.
to so many of your client's words. I can repeat his the way that he speaks, because I've been provided 20 hours worth of recordings and everything. So I'm very familiar with it, and I heard everything that was provided to me.
The way that Mr. DiGiacomo characterizes it, I think, is unfair and inaccurate. He's taking a huge jump and taking liberties with what is actually there to support these allegations.
Understood.
I just want to say, who put this information out in the public? It wasn't Dwayne. It was Detective Kading in 2011. He put all these people's names out there in the public. This was never about finding the truth. Detective Kading was out there to make a buck on this story. Like I said, this is the problem with this case. Is everybody's out there putting this information out into the public since 2011, and it was a cop that put this information out into the public first. Devonta Lee was working with the feds prior to them bringing Dwayne in. He was part of the crew that gave information on Dwayne in that 2008 proffer. They talk about him and other members, and that is why Dwayne was first brought into this. I just think here some of these things that were said, and like I said, this goes back to corroboration, the believability. They talk about this massacre that's going to take place at the 662 Club. I mean, it's just incredulous to believe that Mr. Davis and 4 guys go with 1 gun to a club 662 full of Mob Pyro members and armed security and metros there, and that the 4 of them with 1 gun is going to take out a whole army of people. And this is why I said that these statements are unbelievable. They're puffery, they're dramatized, they were said a certain way to sell books, to sell clicks on YouTube. There is no corroboration. Statements that Lee says about DeAndre Smith, we believe, are inadmissible. Like I said, at first they're inconsistent, that nobody says he was a shooter and then he is the shooter, but at trial we believe it will be inadmissible. Like I said, he wasn't doing it. It wasn't a statement against interest. He's actually bragging. And that's what Detective Kading says, is actually all these people are bragging, trying to get their stripes. So this is actually a statement, I guess, in his interest, but we believe it will be inadmissible at trial, and it is not credible. Like I said, there is no corroboration. There are serious problems with the case, even if you take the words at face value, there's still an issue whether or not this rises to the level of first degree. Mr. Shakur, I'm not trying to discredit Mr. Shakur's legacy, name, or anything, but his history is relevant to a self-defense claim if we go to trial on that issue. All right, what is known about him? What his violent history? It's very public, his violent history. What was known at the time? He's in rap songs bragging about being a mob Pyro Blood member. He's going to kill all his rivals. I mean, this is stuff that was known to the public. It is relevant to a self-defense claim. I'm not trying to discredit his name in any way, but it is relevant for this court's consideration today, Your Honor.
All right, thank you, Mr. Arroyo. Before I rule, I did want to compliment both sides on their excellent advocacy here on this case and their utter command of the complex facts that make up this case. First issue that's before me is whether there's proof evident presumption great to justify holding Mr. Davis here without bail. At this time, the court declines to find that, citing the age of the case as well as the lack of physical evidence. I'm not commenting on the strength of the state's case. What I'm saying is that this doesn't meet the exacting standards laid out by the Nevada Supreme Court in Sewell v. State, which bars the district court from relying on conjecture and inferences and denying bail. At that point, I do turn to the bail factors. And ultimately, I do find that very few of these weigh in favor of release of your client, Mr. Arroyo. The length of residence, I do admit he has lived in Henderson since he finished that parole violation. This is a factor that does weigh for defendant. Status and history of employment is the second factor. His life appears to have been largely illegal employment. He made a living talking about his past life as a leader of the Southside Crips and ultimately the killing of Mr. Shakur in graphic detail. This is a factor that I find weighs in favor of the state. The relationship with his spouse and family, obviously I think that does weigh for the defense. He does have numerous jail calls that show he maintains these close relationships with his family. When I look at his overall reputation, character, and mental condition, his reputation, although it may be older, is as of a brutal leader of a gang. And ultimately, he makes his money, as I said, talking about the victim's death in this matter. I don't believe this is as far behind him based on what I have heard as the defense makes it seem. I think this is a factor that weighs for the state. His prior record is significant but old. He's not been successful on supervision. This is a factor that weighs for the state. The identity of responsible members of the community who would vouch for the reliability of him. We do have a note from his neighbor attached. However, that note reveals that the neighbor doesn't know anything about him, and that's mainly the gist of the note, is that she didn't know that he had this background. Ultimately, this is a factor that weighs for the state. We don't have responsible people vouching for Mr. Davis's credibility and character. The nature of the offense, the probability of connection, and the likely sentence. Overall, I find the nature of the offense is obviously the most serious that we face in the criminal justice system. The likely sentence here is very high given the existing law at the time when this offense was committed. Probability of conviction, one of the biggest things in evaluating cases. Does the defendant give a statement? Yes, he gives many statements here that connect him to this crime, and so I think that's a factor that weighs for the state. When we talk about the nature and the seriousness of danger to any victims or other people in this case, as the state has indicated, this could be very high. There are lots of people who are still scared of him, even in 2022. There are credible threats being made. I don't believe that the FBI is stepping in and providing coverage or assistance for people in situations where they don't think it's a credible threat. And then finally, the likelihood of additional criminal conduct. I find that this weighs for the state, as laid out by Mr. Giacomo regarding the jail calls. Although not explicit, they do cause the court concern. Possibilities of failure to appear. I do find, ultimately, he didn't flee when he was served with this Markham notice. I do note he wasn't entirely cooperative as he didn't sign that Markham notice. And I think at the end of the day, the fact that he didn't leave at that point sort of speaks to the fact that despite this evidence being out there, it took quite some time for it to be charged, and he probably thought that there was no likelihood that it was charged this time as it wasn't charged in the past. So I find this to be a neutral factor. Overall, I find that there's no non-monetary conditions that could ensure community safety as well as Mr. Davis's return to the court. The bail here will be set as a detention order. The court does have to give credence to the defendant's repeated insistence that he was involved in this horrible death. While I am concerned about his medical issues, those can be handled by CCDC. If any issues arise, let me know. I'm going to set bail at $750,000 with a source hearing as well as house arrest. I will look to make sure. We'll see everyone back for the status check on trial readiness that we previously set. Anything further from either side?
No.
Okay,
Oh,
thank you.
just, we do need an order from the court to seal exhibit A.
All right, at this time, I will order the Exhibit 8 be filed under seal and lodged in the vault. For the record, the defense does have a copy of this that has been provided to them as well as the court previously.
Thank you, Your Honor.